And Melissa is one of the members of the foundation board, and she and I are both on a board that thinks that this is very useful to the parishioners. And this is a two-part estate planning seminar based on planning a graceful exit, which we all need to face up to someday. Today is more on the legal side of things, estate planning information. And next week is going to focus more on end of life planning, charitable giving, and funeral planning. So without any further delay, I'm going to turn it over to Melissa.
Thank you, Jim. Well, good morning, everybody. I have to start with the fact that I am not a public speaker. So let me just share that to begin with. So please bear with me. I'll do my best, but I sit behind the desk and draft wills. So this is not something I do often, but I said a little prayer this morning that God would allow me to use my time, talent, and resources to convey my message to you. So hopefully I'm able to do that this morning. So just a little introduction there. I am an estate planning lawyer. That's the bulk of my practice. I have an office here in Marble Falls. My firm is Fox Edge Kuykendall. I do some business, some real estate, but primarily estate planning. So I do not know everything on the topic, but I certainly know a lot about the basics. So I'm going to focus on those today and just hope to give a very broad overview. So with that, I'm going to start with literally the basics, this sort of estate planning 101 here. So what is a will? That's the document by which your assets are disposed of at your death. So it's where you designate who or what organization you want your property to go to at your death. And that's specifically your probate estate versus your non-probate assets. And I'll talk about the difference in those a little bit later, but that's a pretty big distinction. So I am going to go into that also. You can get pretty much as creative as you want to with your will within reason, but there's a lot of different things you can do, or you can keep it very simple. So as simple as all to my wife if she survives me. If she does not survive me, all to my children. That's many people's estate plan. It's basically as simple as that, but you can get a lot more complicated if you want to, just depending on your circumstances. You can give specific gifts in your will. That could be specific gifts of personal property. I give my golf clubs to my friend Bill. You can put that in your will if you want to. Sums of money, you can give sums of money also. $50,000 to Trinity Episcopal Church. That's a provision you could put in your will. We're going to talk more about charitable giving next week. So there's your preview. Something important to note about a will is it has no legal effect until it's admitted to probate. So once someone passes away, you can't just say, okay, I'm the executor, I'm going to get going. I'm going to get started and do everything I need to do. Your will has got to be admitted to probate. So you have to have a court admit the will and give your executor the authority to act. They have to take an oath, and there's requirements they have to follow, and they have to have the authority first to serve as your executor. A good will, a well-drafted will, should plan for contingencies, meaning if I draft it today, it shouldn't just be for my situation as it exists today. It should last a while, right? We don't want to have to redo it every year. I mean, it'd be good for my business, but you don't want to have to redo it every year. I don't want you to have to. An example of that is you can include afterborn children. So my will, when I only had one child, now that I have three, that's okay. I included afterborn children in my will, so I have already provided for them even before I knew I was going to have them. So any well-drafted will should have things like that. I mentioned earlier the all to my wife if she survives me. If she doesn't survive me, all to my children. That's the contingency. That's your plan B. You want to at least have a plan B. You want to appoint an executor of your will, and then you want to have at least one alternate in case your executor predeceases you. So these are all things a good estate planning attorney should alert you to and and plan for. Of course, there's some things that cannot be planned for. So if you already have a will in place, you already have your estate plan set up, I kind of want to go over some things that maybe you need to think about. And if the situation has changed, you might want to take a look at it and maybe need to make some updates. So one of those things would be if there's been a divorce or remarriage, you probably didn't plan for those in your will. So you need to probably make some updates if those have occurred. Another thing is changes in law, which of course happens every once in a while. One of those, an example of that would be the estate tax exemption right now is over $11 million per person. So unless your estate is over $11 million, or for a married couple, that would be, 22 million. Unless your estate is that large, then you don't pay any estate tax at this point. There's talk of that going down earlier than anticipated. I've been reading about lately. So that may go back down to 5 or 6 million, which of course still doesn't affect a lot of people, but certainly more than 11 or 22 million. So anyway, that's just one example of changes in law. Estate tax exemption is, that's a big deal. You don't want to pay 40% estate tax. So if those laws change, you'd want to rethink your will at that point. Another contingency, something you may not have planned for, is if your will was executed outside of Texas and then you move to Texas, you probably want to make some updates. That doesn't make your will ineffective. It could still be probated in Texas if it was executed out of state, but it may not follow Texas procedures and it may be a little more expensive, a little more complicated. So providing for certain things. An example of that was we have what's called independent administration here in Texas. That's a probate process that makes it a lot easier than in other states. So you want to make sure your will provides for that. So some other states that don't have that, it may not provide for that. So you need to look at things like that. I want to talk about some of the issues that can be created by not having a will. So problems created by what we call intestacy, which is dying without a will. So to do that, I have a couple of pictures. So I'm going to see if anybody recognizes this family. Anybody know who that is? Let's see if we can get that. I don't know if I'm close enough. Yeah, so that's the Cleavers from Leave It to Beaver. So, your traditional family, mom, dad, 2 kids. So for this, I want you to suppose, and I don't know that I've ever actually seen the show, so somebody tell me if I'm using the wrong names, but but I think it's Ward and June, or mom and dad. So we're going to suppose for these purposes that Ward and June own a home together. They bought it during their marriage, so it's what we would call community property because it was acquired during their marriage. So Ward and June would both own what's called an undivided 1/2 interest in the home. So when Ward dies, he can only pass his 1/2 interest, not the whole home. When June dies, same thing for her. She can only pass her 1/2 interest. So we're going to suppose, and sorry, Ward, to do this, but we're just going to mark him out. So we're going to assume that Ward has passed away without a will. So at that point, under the what's called laws of intestacy, so the state of Texas tells us what happens if you die without a will and where your property goes. So under those laws, Ward's interest would pass to June. So she would become the sole owner of the home. So probably no issues there. If he had a will, he probably would have given everything to his wife anyway, right? So probably no issues. Let's look at this other family. I know you recognize this one.
Brady Bunch.
Yes, this is the Brady Bunch family. So the Brady Bunch, Mike and Carol Brady, all of their kids. We'll just ignore Alice for now. She's not really part of this, but she's in all the photos. So same situation. Mike passes away without a will, and same scenario. They own a home together, community property. They purchased it during their marriage. So Mike passes away. His interest passes to Carol, right? Just like this situation. That's not what happens in this situation. What's the difference in these two? Here we have a blended family, which is, probably more common than not these days. So because it's a blended family, Mike's children, his interest passes to them. So now we're just going to assume they're adult children for now. So Mike's children own his half, and then Carol retains her half. So now Carol and her stepkids are jointly owning property. And not all families are the Brady Bunch, so you can foresee some issues that might be created there in the joint ownership of property. But I think the overarching lesson there is that's probably not what Mike would have intended for his estate plan. So had he died with a will, he could have left maybe life insurance or something else to his children, left the home to Carol, not created those issues. So the lesson is, the state of Texas may have a different idea than you do of where you would want your property to go. So that's just kind of one illustration of that. Another thing to point out, so now we're going to assume that Mike's children are minors. They're all under the age of 18. So if he dies without a will, his property is going to pass, or at least some of his property is going to pass to them outright. The problem with that is that minors can't own property in Texas. So had he had a will, there would be what's called a contingent trust in there, and their interest would pass in trust to them for their benefit until a certain age, whatever you want that age to be. Commonly 25. If you don't really trust your kids, maybe 35. So just depending on what you want to do, but maybe they shouldn't inherit a bunch of money or a bunch of property right when they turn 18 or 21. So a well-drafted will would have had that contingent trust in there. So those are just two of the common issues, is joint ownership of property and then minors inheriting property. So what would have to happen likely in this scenario is a guardianship would have to be created for the children. Guardianship process is expensive and there's a lot of requirements involved. And as an estate planner, we always want to avoid guardianship. So that's just another one of the issues that can be created. So good little illustrations there. So
question.
Sure.
So you can set up your guardian in your will, right? Or appoint it.
You can appoint a guardian for your minor children in your will.
But if not, if you're intestate, the state's going to decide how that's set up and who it is. How's that work?
So there's probably, there's a guardianship statute. Someone would apply to be a guardian. Yeah. So there's a difference there's called a guardian of the person and a guardian of the estate.
Okay.
So like if both parents pass away, you'd need a guardian of the person to literally take the children. In this scenario, it could be, they may only need a guardian of the estate, which would be to handle the property, okay. Their finances. Okay. So there's that distinction as well. So I want to talk about different probate procedures in Texas. I talked about independent administration earlier. That's something, I don't want to say unique to Texas because I don't know the law in every state, but it is a perk of Texas law. I'll say it makes things a little bit easier. It means that your executor does not have to go to the court to ask permission to do everything. So if they need to sell a piece of real property for your estate, they don't have to ask the court to go do that. They just do it. So it's minimal court supervision, which of course is what we want. Makes it a little bit easier for your executor to do what they need to do. If you die without a will, one of the common procedures you have to go through, and of course everybody's scenario is different, so this is not in every case, but one of the procedures that you would have to go through is what's called a determination of heirship. And that's where the court determines who your legal heirs are, because they're the ones that inherit your property. So that's sort of an extra step that has to happen before the administration of your estate. So you're now paying for the heirship determination as well as the administration. Independent administration can still be available if you die without a will, but it has to be agreed to by all of the heirs. And anytime we need everyone's agreement, sometimes there can be some issues there too, because you also have to agree to who's going to be the administrator of the estate. So it's a lot easier to just have a will and have all that set up. So that's just sort of a broad overview of some of the issues that can be created without having a will, the importance of having one, and then again, a very broad overview of the probate process in Texas and how it's generally a much easier process if you die with a will. I want to talk about incapacity as opposed to planning for your death. Planning for your incapacity is just as important. Not everyone may need that, but it's very common. So when I say incapacity, I mean the legal definition of an incapacitated person. So that would be someone who is no longer able to provide themselves with food, clothing, shelter, or you're no longer able to make healthcare decisions for yourself, or you're no longer able to manage your own financial affairs. That's what the law would determine that you were incapacitated at that point. So that's what that means. And the documents that I include with every estate plan, I draft unless people already have them in order. And there's some additional documents, that depending on circumstances, but I'm going to talk about kind of the big four that I think everyone needs. The first one is a statutory durable power of attorney. So that's your financial power of attorney. So you will appoint an agent to manage your finances. And in the document, there's this whole list of powers that you can give your agent. It can be anything from handling your bank accounts, your real property, filing your taxes for you. All of those things are provided in the statutory form. And I see Nan opening her booklet here. Yes, so these forms, the statutory forms, are in the Graceful Exit book. I will say there are some powers that can be added to that are not in the form. So I always advise consulting an attorney about the forms, even though they are included in here, but it at least kind of shows you a great example of what that would look like. And it basically follows the Texas statute for that. So that's your financial power of attorney. It can be limited in scope, or it can be as broad as you want. You can give them the power to do basically anything. Basically anything within the statute. And that power of attorney can go into effect at the time you execute it, or it can go into effect at the time of your incapacity. But just because it goes into effect immediately at the time of execution, it doesn't take your power away to make your own decisions. You can still make your own decisions. It just allows your agent to act when they need to, without having some certification of your incapacity. So that's an important one. The second one I want to talk about is your medical power of attorney. So that's where you would appoint an agent to make your healthcare decisions for you. And that's contained in the Graceful Exit book as well, your medical power of attorney form. That one, as opposed to the durable power of attorney, that one goes into effect only at the time of incapacity. So you can't make that one go into effect immediately. So I'm trying to think what else about the medical power of attorney. I like to always include HIPAA release authorization in the medical power of attorney. And that's what would allow, excuse me, your agent to access your medical records, talk to your medical providers, because if they're going to be making your healthcare decisions, they need to be able to do those things. And we all know HIPAA and how important that is right now. So you want to make sure you give them access to what they need to be able to make your decisions. So that's the medical power of attorney. I just glance at my notes, make sure I'm not missing anything. I know feel like I'm going quickly. So the next form is called a declaration of guardian. So this is different from the guardian for your minor children. This is a guardianship over yourself. Again, there's a guardian of the person and a guardian of the estate. So in theory, you shouldn't need a guardianship. We hope to always avoid guardianship. That's why you have your powers of attorney in place, so your agents can handle those things. Things don't always go that way. Sometimes, depending on circumstances, you may still need a guardianship. So this document, it's a declaration of who you would want to serve as your guardian. So I always say, put the same people as you designated in your powers of attorney as your agents, put those same people in your declaration of guardian. So basically, it just tells the court, if anyone applies for a guardianship over you, you're saying, this is who I would want to be my guardian.
Now, if you're not predeceased by your spouse, does this automatically become your spouse that does these things or not?
It's not automatic,
Okay.
but they would be the natural choice.
Okay.
Sure, yeah. So the declaration of guardian, I think, is really important for people who maybe don't have a lot of family. Elder abuse is prevalent. And so if someone is able to apply for and obtain a guardianship over you, become your guardian, your powers of attorney have no effect anymore. So agents under your power of attorney have no authority. It's the guardianship only at that point. So it's a good way. I just call it the belt and suspenders approach. You know, you have your powers of attorney in place, but let's do this too, just in case. It's never a bad idea to have it. Another perk of this document is if there's someone you want to exclude as serving as your guardian, then you can specifically exclude specific, persons under this document. So sometimes that's helpful for people too. Maybe you have one child you don't have a relationship with, or, for whatever reason, there's someone you want to make sure they don't end up being your guardian. You can put that in the form as well. So that's helpful. The fourth document that I think everybody should have if you want to execute one is called a directive to physicians. So when you hear someone refer to a living will, that's what they're referring to is this document. So that document says whether you want life-sustaining procedures either applied or withheld if you have either a terminal condition or an irreversible condition. Those definitions are in the statutory form. So what I do for my clients is just give them a copy of the statutory form so that you can make an informed decision. I always advise consulting your doctor about that too. If you have any questions about it, I don't answer questions about that. You don't want my medical advice, I promise. So that's what I always advise with regard to that form. But that's the about life-sustaining procedures and whether you want them applied or withheld. If you don't have a directive in place, it would be your agent under your medical power of attorney, along with your physician, who would make those decisions for you. How are we doing? Good. Okay, I have some time. Okay. I just want to talk about one more topic. I think we'll see. And those are, I said at the beginning, your will is how your probate assets pass as opposed to your non-probate assets. So I just want to make the important point that non-probate assets should not ever be an afterthought in your estate plan. Sometimes it's the bulk of someone's estate. So non-probate assets are anything that passed by contract. So anything with a beneficiary designation, life insurance policies, which can be a big chunk of someone's estate, retirement accounts, anything, if a bank account has a POD designation, a payable on death designation, that would pass according to that rather than under your will. So those need to be coordinated with your estate plan. If you have a trust, if everything is going into trust at your death, then the trustee of your trust should be your beneficiary, so that those go into trust as well, if you want them to. So all of this stuff kind of works together. And I'm not going to get into the specifics of it, but I think the main takeaway is non-probate assets are not an afterthought, and they should coordinate with the rest of your estate plan. So you always want to make sure you have those beneficiary designations set up the way you want them. And a tool that I've been using a lot lately in estate plans is what's called a transfer on death deed. And that's something that's created by statute in Texas. And that's how you can pass real property on your death automatically without going through the probate process.
What's it called again?
It's called a transfer on death deed, or TOD, TODD is it's a transfer on death designation. So that can be a really big deal, because sometimes the only reason your estate needs to be probated is because you got a piece of real property, and you can't, there has to be some kind of probate process for that chain of title to pass. If there hasn't been a probate process, and say, in this case, if June never probated, did anything with Ward's, will or intestate estate, she goes to sell her home later, Ward's name is on the deed, she's going to have some problems. A title company is not going to close. You're going to have some issues. So there's got to be some kind of either probate process, or you can execute this transfer on death deed, which makes real property pass non-probate. So sometimes, like I said, you can avoid probate altogether, which is wonderful. Even though probate, with independent administration, it's not as cumbersome as it is in other states, there's still some requirements and some expense involved. So, if you set up your entire estate plan to be non-probate, then you don't have to mess with the probate process at all. And sometimes that can be easier. Probate cannot always be avoided, but that's a pretty cool tool to be able to use. So yeah, just wanted to point that out, because that's handy to have now. Trying to think of anything else. If anybody has any questions, I'm happy to try to answer them. I don't always have all of this information at the front of my brain, but I'm happy to answer questions. And then, like Jim said, next week we're going to talk about charitable giving some more. So I'm going to talk about different ways to do that in your estate.
I have
Sure.
a son. So what happens with state law?
You have a what? A son out of state. So it really, the state law that would apply would be where you reside at the time of your death.
Would it be advisable to have an executor in the state of Texas then? Rather than
If you can, it might make things easier. But with independent administration, there's not a whole lot they have to do. They only go to court one time. So they go to court to be appointed as your executor. And then after that, as long as, like I said, as long as it's independent administration, then they're sort of on their own to do all this stuff. Practically, would it make it easier? Maybe. With some of the non-legal things they need to do just to wrap up someone's estate, but it's not a requirement. I'll say that.
In Judy's case, one son, right?
right.
Can your one son also be the executor? Can the
Absolutely.
beneficiary be the executor? Because I kind of had that with one of my sons.
Absolutely.
Okay. Can the one son also be your executor? And she
Be
said-
my
Executor
executor.
of the will.
Oh.
And the answer is
And
yes.
she said, yes,
okay.
can. So that may simplify things too.
Yeah, absolutely. There's no requirement that your executor be someone other than a beneficiary. In fact, they're very commonly a beneficiary. So, generally you'd appoint your spouse as your first, your first nominated executor. And of course, probably everything's going to them anyway. So makes it pretty simple.
For those of you who are at home, if you have a question, just raise your hand or type it in the chat and we can answer your question. And then next time you're here at church, be sure to pick up this booklet that we have for you with all these forms.
I think I have another question. How viable are photos of things that you want given to someone specifically? Can that be included as part of your will?
So it can't be included as part of your will, meaning don't attach it to your will and it would have no legal effect. But the way I like to handle personal property is I put a provision in the will saying that you may leave a memorandum. And so you're directing your executor to go by your memorandum. because personal property changes so much and you don't want to have to change your will every time you change your personal property. So you just direct your executor to look at your memorandum. If you wanted to leave photos with that, I think that's probably a great idea. And that way you can write a memorandum saying, I leave my diamond necklace to this person. I leave, this to this person. So the golf club example I used at the beginning, you can do that if you want to, but I would always say, well, do you really need that in your will, or can we put that in a memorandum? Because maybe you stop playing golf and you don't even have those anymore. So, you don't need that in your will. So that's how I like to handle personal property.
Where do you see the biggest problem in settling an estate? I mean, you see this all the time. Where's the biggest holes? Is it just your survivors not agreeing on something and your will left a hole in there for them to have that disagreement about who has what? Or
Well, so I guess that depends on whether you're dying with a will or without. With a will, I don't see a whole lot of that because it's in there, you got it in there. You can also do what's called family settlement agreements if you want to do something other than someone's will. I haven't done a lot of family settlement agreements, but I know they're out there. But really, I reached out. There's a Facebook group called Texas Lawyers, and it's a huge group of lawyers in the state of Texas. It's a wonderful resource. I use it all the time as a fairly young lawyer, and reach out to those who have been doing this for 30 years. And so when I said I was going to do this presentation, because I know a lot of estate planners typically do these. So I said, what do people need to know? What are the questions you are most commonly asked? What's your, top items you would recommend me talking about? And the ones that I mentioned, the blended families and the problems created by dying without a will if you have a blended family was number one. So that's probably what I see the most. And I think that's, typical of other lawyers from the feedback I got. So that, and then the other thing people said to talk about, which I don't really know much about this, but apparently there's some kind of AARP national magazine or something, and a lot of people use that as a resource, and it's not specific to Texas law. So make sure the resources that you're looking at are specific to Texas law, or it may not be, all that helpful. They can still have some good tips, and people who do wills online, I've looked at some that I'm like, actually, this is pretty good. I don't even think I need to make changes. But most often I say this is good, except it's not Texas law. So you need to make, a few changes because of that. So
since I'm involved in real estate a lot, I see time and again where pieces of property are left to beneficiaries, and then they can never agree on anything. But once you leave it, it's out of your hands. You just bless it and let it go, right? I mean, unless you're a real control freak, you can't put in your will, now they got to do this or that.
Actually, there's a lot you can do. You can direct your executor to sell it and split the proceeds among your beneficiaries. So that's a good way to avoid that if you foresee, some issues.
You see that with family farms a lot.
Absolutely, yeah. And that, that goes back to that joint ownership of property. Maybe even if it's not a blended family, maybe, joint ownership of property is not going to be a good idea. Maybe you've got the big family ranch and one child really wants to keep it and one child wants to sell it, you may end up with a partition suit. You can kind of split it, or joint ownership of property may be fine, or it may not go so well. And usually, people have a pretty good idea of their beneficiaries, and if it's not a good idea, then there's other things. Or maybe, if you've got a family business that one child runs and one of them has nothing to do with it, maybe you don't want to leave that business to both of them. Maybe you leave a life insurance policy to one, and then you leave a family business to the other. So when I say you can get pretty creative depending on your circumstances, you really can.
I think the bottom line gets down to know your beneficiaries. you know? I
Absolutely,
mean,
yeah.
especially your kids, oh my gosh, they're so different.
And you can't foresee everything, of course, but we can set them up in the best way possible to make it a seamless transition and make it as easy as possible on our family members, which is, you know, what most people want to do. Sometimes I have clients that say, I'm doing this, and they can fight it out, and I don't care because I won't be here. I was like, oh, okay. But the vast majority of the time, you know, people want to set their families up to be taken care of, and for this to not be a burden. So, you know, setting up your estate plan that's a great reason to do that, is to provide for your family and make sure you're not leaving a burden at a difficult time already. So
I have a question, because I didn't know about probate, that most wills have to be probated. So, let's say I die first, what's the first step my spouse, and I have a will, what's the first step my spouse should do?
see a probate attorney. So,
Are you a probate attorney?
I am, yeah, I do a little bit of probate, but yeah, that's the first step. And of course, that doesn't have to happen immediately. You know, I have clients who wait months, and sometimes that's okay, and sometimes it's kind of difficult. You know, it depends a lot on your specific estate. Probably if it's your spouse, they've got access to what they need, you know, already, but that may not always be the case. But yeah, you do. So you have 4 years to probate a will. That's the statute of limitations on a will, is 4 years. But don't wait 4 years.
But for the executor to start working, they would have to probate.
They technically have to have the authority. Yeah. Sometimes, you know, my legal answer and my practical answer are sometimes different. You know, don't leave things undone. I mean, don't, you know, not go over there and lock up the house and keep the bills going and things like that. If they need to be, you know, don't just let the property go because you don't have authority to do that. Of course, you know, because once you are appointed, you do have a fiduciary duty to the, you know, to manage all of these things. So that's sort of a situation where maybe the practical aspect is a little bit different from the legal aspect, but one of the first steps is go see a probate attorney and get that process started pretty early on, and it might make it easier.
It usually take to get something. Make a reservation in advance, or
So it depends on so many things. You know, how long does it take to get an appointment to go see the probate attorney? How long does it take to get a hearing? So that'll depend on the court you're in, and the county. Burnett, Llano counties, I usually don't have trouble getting hearings pretty quickly. With COVID, everything was backed up. So, you know, it depends on that, because they don't have authority until you know, take that oath and you get appointed by the court and have that hearing. And then once you get that process started, you know, it'll depend on if the estate's got a ton of creditors they have to pay, you know, things like that before they can get property distributed. Or if everything is left to charity. I've got one will I've probated where everything was left to American Cancer Society, and they don't want your property, they want the money. So we have to liquidate the entire estate before you distribute it, you know. So if a home sits on the market for a while, you know, before we can do that, then so it totally depends on the circumstances. It's not a super quick process though, as most legal processes are. So
Melissa, is there any benefit to having like a living trust as opposed to a will?
so
If we said they get a little bit louder for the folks at home.
Is there any benefit to having a living trust as opposed to a will?
that's a really good question, a question I get asked a lot. So revocable living trusts are a lot more common in other states than they are in Texas. And again, I'm going back to that same concept I keep talking about, which is we have independent administration in Texas. In states that do not have independent administration, the probate process can become so expensive and so cumbersome. It's easier to have a trust so that you don't have to probate. Hopefully you don't have to probate if all your assets are in trust. It's not something I commonly do because you have to have the trust funded. So all of your assets need to be retitled and be put into the trust. And most clients just don't want to mess with doing that. There are some perks to it if you want to, be sure you avoid probate. There's some perks to doing it. There's more privacy that way. A will has to be filed with the court. And now records, are online in most counties, so I can go look at someone's will if you don't want someone to see that. There's more privacy and a trust. So there's some other reasons to do it. The vast majority of what I do is wills as opposed to living trusts, but it's certainly an option.
So it might be more beneficial if you lived outside of Texas.
Yeah, depending on what state you live in. I don't know but I see a lot of out-of-state living trusts because they're so much more common in other states. So, but it's certainly an option. There's lots of different options. I'm just kind of talking about a broad overview and what I typically see and what I find most typically that clients are looking for. But
King, were you waving your hand? Did you have a question? King and Karen? No. Okay. What else are you wondering about?
Well, I for one cannot wait till the second one. Thank
well,
you.
me neither. I won't talk the whole time next week. I promise that. So, well, I appreciate that. I hope that I at least provided something
absolutely.
beneficial. I haven't done enough of these to sort of know what the most helpful information is. So I hope I at least taught you something.
Absolutely.
I think another thing for us is we're, planning a graceful exit. I love this title here. We came up
I
with,
do too.
is to talk to our children if we have children. That's one thing I'm always grateful to my parents. They were very clear early on. They wanted to be cremated. We even knew, what was their favorite hymn to do, which there's a funeral planning section in here. But, as you pointed out, at the time of death, you're so, emotionally overwrought many times that it's hard to kind of figure out all these details. So this is a gift to our beneficiaries. I think to talk to them ahead of time, but also to have it down in writing. It's a kindness we do for our families.
Absolutely. Yeah. And I'm sorry, go ahead.
No.
It's not things that we always want to think about. And I mean, I have to, I was going to mention, I talk about this casually and, I'm just marking through people and I don't mean to talk about it casually. I do it because I do this every day and I talk about it so much, but I do understand that it's, it's not always a topic people want to talk about. And I have to bring up the situation of, well, if one of your kids predeceases you, how do you want to handle that? And so it's hard decisions to make. But, if we make those decisions now and get everything in order, we're making it easier, on our families in the future.
And cleaning out the attic ahead of time. Which is still on our to-do list.
Yes, that's what I told my parents, just please get rid of all the storage units and all that stuff and I'll be happy.
Any last questions?
Melissa, thank you very much for your time on this, and your preparation. It is very valuable to all of us.
Okay.
And, thanks.
Well, I'm happy to do it. Thank you for being here and listening to me.
We look forward to next week.